fix
Okay.
that.
Okay, so we are live. Give me 1 second to set up the Telegram. Welcome everybody, the early birds that show up first. Stream with. Oh no, that's not how to do it. Live stream with. Start streaming.
Oh, I can hear the heavy rain at your end, Curtis.
Okay. Welcome to Let's Talk Immigration. Are you there, Chuck? Are you there, Rabia?
Yeah, I think Rabia dropped off to fix her audio issue. But I can't see you now.
Wonderful. I'm going to retweet the thing. I don't always show up. That's weird. I think the internet's like spotty because it's cloudy.
Go next.
So for you just joining, I'm Curtis Morrison. I own Ready Go Law, and my guest here is Chuck Go, our senior attorney, and we could be joined momentarily, which we are, from senior paralegal Rabia. Welcome, Rabia.
Hi, hello everyone. Thank you for having me.
Hi, everyone.
So first, I want to talk about like recent developments that we haven't talked about since last Wednesday's show. The USCI, well, first it started with Kristi Noem. Kristi Noem tweeted out something about like, I'm going to end the DV program. And then right after that, on Friday, the next day, USCIS actually published a memo where they are suspending all benefits related to the DV program. And then State Department has not posted anything about that, but as far as like for people going through the embassy process, but reports back for people that attended the interviews over the weekend and Monday, they were all given 221G notices. All the diversity visa selectees who showed up to interview were given diversity visas. Went into administrative processing. So what that tells me is Secretary of State Rubio has sent a cable momentarily or indefinitely, I don't know, putting a hold on the DV program. That's not lawful. We've got 2 judges in the past in 3 different lawsuits saying that that's not lawful. So I'm sure that litigation will fix this, but we have to do it first, have to do the work. So on our website, we've set up an interest list for DV 2026 selectees who want to participate in a group lawsuit to challenge both the suspension of the DV program in the U.S. By USCIS and the State Department's suspension of the program, neither of which are lawful. Actually, if there's somebody who could throw that link up for interest list, actually, I think I can do it. Yep. Okay. So that's the latest development since last Wednesday. Now I want to talk about what we've been up to. We've been onboarding a group lawsuit for I-4085 applicants, adjustment of status applicants whose applications were put on hold due to the December 2nd USCIS memo that paragraph 2 put them all on hold. Onboarding for that first wave of group lawsuits in that situation ends on Friday. Go to our website, readygolaw.com, and it's the banner to onboard under that. As of earlier today, I can't remember, it's 17 or 19. Rabbi, do you remember? I think there's 17 primary applicants.
I think 19 was the
Oh,
latest.
19. Okay, 19. So we're definitely moving forward with that lawsuit. I expect a lot more people will join, but whether or not they do or not, we're moving forward with that litigation. And it'll be one or more lawsuits depending on how many people do participate. Also, this week, we set up a web page for a group lawsuit on behalf of 765 applicants. That's for people applying for work authorization, whether OPT or 765 with pending 485, like adjustment of status, or for family-based, employment-based, asylum-based, whatever. If you're applying for a 765, you can participate in that group lawsuit. Onboarding has not started on that. I expect it'll start in the next few days. But we wanted to get the details out there about that opportunity. Some people have asked, like, can I participate in both cases? Yes, of course, if you've got pending applications, both the 485 and the 765. And if you do that, we're going to give you a discount on the second case. Like, you only have to pay $1,000 and you get to participate in the second lawsuit. So those are the two group lawsuits that we are onboarding right now. We do have an interest list. We have more than one interest list for different situations out there where we will probably be challenging Trump policies in the coming spring and the coming year. But those, the only two that we're onboarding right now are people with pending 485 and pending 765. So what should we move on to next? Rabia, you have ideas?
Yeah, do you want to talk a little bit about the travel ban, because it's going into effect for people processing at consulates abroad, just what they want to watch out for, what matters to them, how it impacts, especially the new categories, right? Children, spouses, and parents of US citizens didn't have to deal with that in the past, so there may be many, many question marks for families in those categories.
Right, and a lot of people are reaching out to me saying, hey, why aren't you doing litigation around the travel ban? So this is a good chance to talk about that. Basically, Trump last week put into effect a new proclamation that expands not only the number of countries subject to the travel ban, but takes away the exception for immediate relatives, takes away other exceptions too. The SIV exception, they took that away, right? So we're very familiar with travel bans and challenging them in court, because we have like 8 pending challenges now, 7 or 8 in federal courts across the country, like 4 different courts. But we're going to focus on our challenges to the June 4th ban, and we are not bringing new challenges related to the ban that just came out. I understand my colleague, Charles Cuck, is launching a lawsuit called, well, I don't know what it's called. It's Impact Litigation is the name of his website, where he's onboarding that lawsuit. And so if you're very eager to participate in litigation to challenge that new ban, go check out Chuck's opportunity, because we're gonna try to see through our existing lawsuits on that subject before we bring new ones. So as far as what Rabbi is saying is, let's talk about what it means. It means, if you're an immediate relative of a U.S. citizen, but you are a citizen of one of those 19 countries, I said 19. Was it 35 or 40?
39.
39 countries. That means that you are not going to immigrate or travel into the U.S. for the next 3.5 years until Trump is gone, most likely. And I realize it's very frustrating. It doesn't go in effect till January 1st, though. So if there's a way you could get your visa issued this week, I mean, if you're beside the embassy and you could drop off your passport, get that thing printed before January 1st, you'd want to do that. But a lot of people are already trying to do that, some with success, some not. So it might be a little chaos. But there's only 3 business days left in the year, right?
Yes.
Yeah. So, but it goes into.
It depends on the embassy, right? Some are open on Sunday, but I think the ones that are open on Sunday are closed on Friday. So yeah, either way, it's great. Yeah.
Right. So if you do have an issued visa and you're like, oh, am I subject to this ban? No, as long as your visa is not revoked. I would recommend that you do not take that risk. If you have an issued visa, you need to get on a plane and come to the U.S. Anybody that's followed me knows that I say that frequently.
Yeah. While we're
Um,
talking about interviews, would one of you also want to expand a little bit on the difference, right? 2 to 1G is what applicants get when they get an administrative processing or when documents are missing. But starting January 1st, applicants from those countries will see a 212F refusal.
right.
How that's different and may impact decisions whether or not it's recommendable to attend interviews at this time.
Right. This is a very common question, and it's a frustrating question because we can't give a definitive response. What we can say is based upon experience. When Biden took over in January of 2021, he issued a proclamation that gave a path to prior 212F refusals to move forward with their applications. We don't know who the next president will be or if they will be so accommodating. So, also, there's no way to make a second visa application on an approved petition without some intense work. I mean, there's no place on the website to do that, right? And so I just think that there's going to be a little bit of unpredictability with your situation if you attend an interview and get a 212F refusal. So I recommend avoiding that. If you're scheduled for an interview but you're not eligible for a visa, do not attend the interview. That's my advice. But we can't really know how people will be treated later. I'll give a funny example about that. Not funny, but there was litigation called Amami versus Pars in 2017 that went on all the way until 2025 and ultimately got relief in some form for people that were victims of the travel ban for like visitor visas, and they got to reapply without a fee, and they got priority interviewing, but all that was contingent upon they had to have a 212F refusal. So there's a situation where people actually benefited from getting the 212F refusal. See how unpredictable this is? But my advice is don't attend the interview if you're not eligible for the visa.
Thank you so much. On that topic, the State Department implementation with the no visa policy, the updated implementation came out late last week, and it mentioned, right, that the department may permit travel by an individual who would serve the U.S. national interest on a case-by-case basis. So we're seeing lots of chatter about maybe it's worth attending and seeing if an applicant qualifies for a waiver.
Right.
What do you think about that?
Right. And I understand why people are talking about that, because during Trump's first administration, there was a waiver, a three-pronged waiver to Proclamation 9645. And so people would attend interviews and they would hope to get waivers. But the current two travel bans that Trump has put into effect, they do not have a waiver provision. There's no waiver provision. And as to the extent you could say that the national interest exception is a waiver provision, because the word waiver does appear, I think, once in each proclamation. No one has got one. Okay, so June 4th is when the first proclamation was issued, went into effect June 9th. No applicant, I mean, like, we have a lot of clients, but also I have a lot of colleagues who have clients, and I'm on the telegrams, and Ravi is there, and we're on these networks and forums, and we would know. Okay, no one's got a national interest exception. So if you want to try, knock yourself out, but just understand the odds that you're the first are pretty low.
Curtis, so you were discussing our challenge to the June travel ban PP 10949, and we have a recent update to that. Can you maybe tell our audience on that a bit on that?
Oh my goodness, we do have updates on that. Let me give the updates that I know, and you can tell me the one I missed. So we have an appeal before the DC Circuit on that issue, and that'll be in DC in February. I think Garrett May, one of our attorneys, is making oral arguments. I think Chuck is going to go to DC, maybe. You just got admitted to DC Circuit. Congratulations.
Congrats.
Let me see here. So that's one thing that's going on. What's the other thing going on? Okay, so Judge Chutkan issued an order on in our two of our lawsuits, Ariana, CM 178, and Jahani, CM 328, for employment-based and students, respectfully, where she's allowing us to amend the complaint not to challenge the travel ban, but to challenge the way the travel ban is being implemented. And Chuck, that's part of the update you were talking about, right? Because you're working on it.
Yeah.
Right. Okay. So she's allowing us to amend the complaints. And what's interesting is CM 178, we're actually challenging the national interest exception determination because a lot of the plaintiffs in that case are exceptional Iranian employment-based visa category, and they're NIW. EBNIW, USCIS found that they were in the national interest. And then the State Department's coming back and saying, well, we have a different definition for national interest. Oh, come on. You can't, it's one government. You can't have different definitions for words from one branch to the other. So she's letting our challenge move forward in that case. And both of these lawsuits, by the way, before the same judge, have been consolidated. So we're going to make arguments together like they're the same case. One's on behalf of, like I said, employment-based Iranians, and the other one's on behalf of students. And both of these cases have something else in common that's really strange. We tried to file them in other district courts, and those courts that we tried to file them in only took care of the plaintiffs that were venued in that district and transferred these cases to DC. Ariani started out in LA, and Central District of California, and Jahani started out in Missouri. So that's just a reminder for everybody that's asking questions about venue. What can happen with improper venue? If you file a group lawsuit and the government convinces the court that it's not venued in the right place, they could transfer it. Okay, that's me talking a lot.
But thank you. I think that's important context, Chuck, for bringing that up. I had one question that I have been hearing a lot over the past week while folks are deliberating whether or not to join litigation, whether that's with us or one of the other firms. And we have that as a question in the comments already as well. People are concerned about retribution, whether they can file a lawsuit against the government without risking that they come after them. What are your thoughts on that?
Okay, so I've only done this since 2018, and I've not seen retribution or retaliation by the government on one of our clients because they did litigation. It doesn't happen. I believe it doesn't happen for two reasons. One, it's not lawful. Immigration decisions have to be based upon the Immigration and Nationality Act. They can't base the eligibility on, we're mad at you because you sued us. No, that's not a factor in determining eligibility for an immigration benefit. But the second reason, and I've told people this individually, my mother used to work for the federal government, and I understand a little bit about how people that work for the government approach their jobs, and they want to do their job, and they want to leave every day at 4 o'clock, and they are not emotionally invested in hurting you. Like the White House might be, Stephen Miller might be, and he might make policies that are harmful. But the individual decision makers at the embassies, at USCIS, they're not bad people, and they're not going to try to retaliate against you.
Thank you. I hope that helps those who were listening. And Shaba, thank you for asking that here as well. One last question I've been getting for the lawsuit that we are currently onboarding, or lawsuits plural, and that's the direction the question is going into. the group lawsuit onboarding makes very clear that we're intending to file possibly 2 or even more groups. What's the thought behind keeping groups smaller and not just filing one huge challenge?
Great question. Part of it is strategy around proper venue. As I mentioned before, 2 of our high profile group lawsuits had got transferred from other districts to DC. It is unclear when you're challenging a USCIS policy where they would transfer it to, because USCIS is located in Maryland, but the court there doesn't like these kind of cases. They don't like individual delay cases. I don't know about change of policy cases. I don't know. Chuck, maybe you could give me thoughts on that.
The last hearing I heard about in the Maryland, I don't think the judge is very friendly. Even with policy challenge cases, they want to transfer the cases to DC. That's what I remember 2 years ago.
Well, see, you can't sue in DC though, because DC says you have to sue where the office is. So I think that it's an interesting thing. I think we don't know where they're going to transfer to unless we make Secretary Noem a defendant, which we might do, and then maybe DC is where they will want to hear these cases. I feel like no matter where we file these lawsuits, they're going to try to transfer them to a different court. But so since these are adjustment of status applicants in the 485 case, it's different than the 765. The 765 case, we might just file one case. But the 485 cases, if there's 10 people that are located in LA or 10 people in Chicago, we're going to file a case there. Maybe I should say 20. I don't know. I'm going to wait and see who is where once everybody's on board. I know that, Chuck, you just poo-pooed Maryland, but remember, I started out this year, I flew to Maryland. It was very cold in January and won a preliminary injunction on behalf of Iranian visa applicant in administrative processing. And that was the only time that happened this year, and it happened in Maryland. So I've got, well, I guess we won preliminary injunction and fine in DC, but it was different. It wasn't all Iranians. So anyway.
So we're not writing Maryland off.
I'm not writing Maryland off. I like Maryland. So anyway.
Awesome.
Also, some of our plaintiffs that have signed up are in Maryland too, which is helpful. So that means the memo is written there, the defendant is there, and the plaintiff is there for at least some of them. Okay.
Awesome. Thank you so much. Speaking about lawsuit decisions, there's a question here from Bimoniri. I hope I'm saying that correct. Is one of the 2 of you already caught up on what happened in the Chamber of Commerce lawsuit? That's the H-1B lawsuit where Judge Howell issued an order today, I believe.
I think there's a hearing recently, and the judge in DC she probably indicated that she's kind of on the government side. That's what I heard from news. And last month we were trying to organize a litigation based on the similar issue, and we were not able to get enough plaintiffs to sign up for it. So we didn't file anything.
Right. So I'll add one more thing. There's more than one case, and there are 2 other cases. Maybe Chuck knows more about them than I do, but I was really surprised that the Chamber of Commerce's attorneys were able to screw up that badly in front of Judge Howe, because I think I mentioned this in the Telegram group that Judge Howe, in one of Charles Cuck's cases in 2021 called Tate, plaintiffs were in the 01 category, found that 212F was just an entry ban and it couldn't be used for anything else. Well, here it's being used for something else. So I haven't read her order, but I'm just like, how did they lose in front of her when that's her point of view? I don't know. Well, I'll have to check that out.
I don't think she issued that order yet.
Yeah, she did.
Also, the other
today, I think.
Yeah, the order.
Today?
It was. I think it was last night. Yeah.
Oh wow. Yeah. Okay.
Yeah.
Oh,
Yeah,
it's
That's
true.
that's what the
True.
question specifically asked for. Yeah, yeah, yeah.
Uh,
so.
the other lawsuit would be from the impacts litigation team with unions and hospitals, uh,
Right.
or yeah, or agent nurse agencies. They are also several states sued as well. So we'll see how the other
That's
two goes.
probably. Do you know which court that one's in?
No.
I don't either. I can't remember.
Okay, thank you.
I'll add one more thing to that. Okay, so we positioned ourselves and talked a lot about the HB1 lawsuit right when the proclamation came out. And it's just one example of like why you pay a price to be first, because we had our litigation completely planned out when we thought that the $100,000 was going to be stuck on the beneficiary. And then they quickly clarified that. They reversed it 2 days later from what it
Yeah,
said to mean something else. And that's why we had to switch directions on our strategy.
that's very true. I believe the blowback there after that came out was huge.
Yeah.
The behind closed doors blowback.
Yeah.
Yeah. Um, do we want to move on from that? We have a DV 2026 question.
Yay.
What happens? It's Maximus Cryptos. What happens if they hold the DV 2026 cases SAP until early September? Is that possible? Can they issue AP cases fastly, or can the court prevent that kind of move?
Um, oh, it's possible. If you don't take them to court, that's exactly what they're going to do. They've tried it before. And um, we need to talk about 2020, because in 2020, the Trump administration suspended the DV program and got away with it for the first half of the year. This is interesting because we get to talk about our two colleagues that are also doing group lawsuits now. Jim Hacking, to his credit, brought the first lawsuit challenging that with a diversity visa plaintiff, and it went before Judge Mehta. The case was called Nguyen, Nguyen, and the judge did not. I think he denied the motion for preliminary injunction and also like dismissed the case, if I remember right, because he said that like nothing to see here. This isn't an unreasonable delay. This suspension has not lasted that long, and nobody's facing an injury because it's not until September that the fiscal year is over. 2 months go by. We bring three lawsuits. Mohammed Fong well, and then Charles Cuff brings Acre, and then we brought another lawsuit called Kennedy in September. By that time, Judge Mehta was mad because the government's representations to him in April and May were false and that he had been lied to. And so he was completely prepared to give us injunctive relief, which he did. And the State Department moved heaven and earth, and many DVs were issued visas in September of 2020. Um, and that was because of the litigation that I participated in. There were lots of lawyers though. Why did I tell that whole story? I don't even know. I forgot.
Because Maximus Crystals asked if it's possible that they will
Oh,
hold cases in
yeah,
AP just until the fiscal
right.
year is over.
So if they do that, that makes our case stronger. Does that make sense? The closer we get to September, it's really like a balancing act. Because if we bring a PI now on behalf of DVs, the judges are going to do the same thing. They're going to be like, really? Is it an imminent injury? Because the fiscal year isn't over until September. But the closer you get to September, the stronger the case gets, but also the less time you have to get the relief. So it's tricky. But we're going to do DV 2026 lawsuit for sure.
Thank you so much. We have a question here from Nikesta. Is your I-485 lawsuit only for the 19 original countries, or can anyone from the 39 countries join?
Great question. The 19 original only, and the reason is we do not have evidence that USCIS has issued a new memo that expands that hold to the 39 countries. I check that website. If you type in the word USCIS memorandum, it's memoranda, I think, into Google, there's a website USCIS has where they release their policy updates. You can also sign up to be notified. And I'm waiting to see if USCIS does that. But to my knowledge, they have not publicly expanded that policy to all 39 countries.
Thank you so much. Yeah, and I'm just checking now. So the DV from December 19 is the last update.
Okay.
So if that would change, then we would possibly, if we offer another challenge for I-485 later on, we would open that up to the countries if there's a formal policy, right?
Right. I think it would have to be a later on case, though, because our retainer agreements and our prospectus on this case is specific what we're doing, and I feel like I have a legal ethical obligation to do exactly what I said I was doing with this particular group.
Yeah.
Okay.
There's the follow-up question. Would you happen to know why they aren't expanding? Are they chickening out?
I don't even know why they did the thing in the first place, so I don't know why they would expand it. I don't know. They could have expanded it, and we just don't know yet because they haven't made it public.
They're probably waiting
Also
for another
remember,
event they can attach it to, because that's how policy updates are being launched at the moment. It's all
Right.
technical publicity stunt.
also remember when the PP 10949 just published within 1 week, they are saying they are going to expand it to 30 additional countries.
Yeah. So, and then they didn't until now. So things can take longer than they planned. Hey, what's one of these countries? What's the Syria? Okay, so let's say somebody from Syria gets a parking ticket today. Well, that'll be the grounds. That'll be the reasons. That'll be on the news, or somebody from one of these new countries. They've got a Google News alert right now. Just this was in House of Cards, actually. When the government wants to roll out a policy and blame it on an immigrant or something, they're waiting for an immigrant to do something wrong, and then they're going to make an announcement. Crazy.
It is.
Uh,
Bad.
so Curtis,
we're having
recently we have a EB5 successful story. Do you want to talk about it since we don't have questions from audience anymore?
Oh yeah, so I got hired from. You might remember the length of delay. I don't, but there was a pending I-527 and a pending 485. We filed the lawsuit in the Northern District of California for an EB5 applicant, and the government has to answer the complaint within 60 days, right? And I don't know if it was because of the lapse in appropriations, the government shutdown, or what happened, but the government did not file the response by the time it was due. And I let a couple of days go by because I thought maybe I did the math wrong. And then the judge issued an order directing me to file default entry of default judgment. No, entry of default. And then I filed it, but I didn't do it exactly the way she wanted. So I redid it. And so in the meantime, they've already approved the 526, and they said that they're working on the 485, and it's going to be approved within the month. So that just shows you right there that, litigation works, y'all.
Yeah, that's an amazing thing.
We might get attorney fees in that case to where I can refund the clients. Right. Yeah, I'm fighting for them. We'll see.
That's amazing. We got one more question here from Maximus Cryptus. When we are going to start the DV challenge, the timing is crucial in these cases. If time runs out, they will say there's nothing to do. That's what Curtis just explained, that timing is a very sensitive thing for DVs. If the lawsuit gets filed too early, a judge may say, no, there's no urgency yet. That's what he explained
Right.
earlier about the lawsuits that were filed early and didn't go anywhere, and then lawsuits that get filed late. That's stressful for plaintiffs if relief is granted and they have to rush to embassies and get everything done quickly. But that's the moment where judges feel the urgency, right?
Yes, but also for me to be able to democratize the cost of this litigation to where it's more fairly distributed amongst all the victims, I need you all to circulate that interest list. I mean, if you're out there in the community and you've signed up on the interest list and you know someone else who is a victim of this and has not signed on the interest list, another DB26 selectee, share it to them, tell them to sign up, because we make our decisions on which group lawsuits we're moving forward with next based upon what I'm angry about, based upon what our team is angry about, but also based upon the demand. And if we see a huge demand, we're going to okay, let's figure out how we can do this.
Awesome. And you're getting a thank you so much for that. So that's
Wonderful.
good. Nixta is asking about the prospects of success of the I-485 lawsuit, if it makes sense from a judge's point of view as to the suspension, the pause at USCIS.
Right. So I have an 80% confidence rate that we are going to prevail in that lawsuit. And I'll tell you what, it might have went up to 85% this morning because an Iranian law student at UCLA, UCLA Law, has written a memo, kind of as a volunteer because he wanted to help, and he sent it over to me. Chuck, that's in the folder for CM613 if you want to review it, and had some good ideas there that I had not thought about. So I don't know. I'm really confident that the government's going to find this unlawful. It's national origin discrimination, and usually we don't get to use the Constitution in our lawsuits because we file the State Department and our plaintiffs are abroad, and you don't have constitutional rights when you're abroad. But by definition, everybody that's filing a 485 is not abroad. They're in the United States and they have constitutional rights. So I'm optimistic about that, but I'm also optimistic about the Administrative Procedures Act because this is a withholding, not just an unreasonable delay, but a withholding of a benefit. And there's good law on that to support us.
Thank you so much. Then there's one question asking again about the Chamber of Commerce lawsuit, but you have discussed that at length. So Amy, Pat, maybe watch the beginning of the live later on, and Curtis and Chuck have discussed that there. Roger is asking, how confident are you in the DB 2026 lawsuit success? Do you expect the visa bulletin cutoffs will keep going given that state allowed embassies to schedule new appointments? Sorry, that's actually two questions.
Yeah.
Let's start with the lawsuit success.
Very confident about the lawsuit success, but understand that we will not be moving forward with that lawsuit probably until February or after, and sign up for the interest list if you're interested. To the second question, I'm so glad I got asked this question because I want to make a prediction and I want somebody to say, hey, Curtis said that on December 24th and he was right. I think the same thing's going to happen to the visa bulletin that happened in 2020. What I mean is the algorithm is going to get confused by the fact of fewer DVs being issued because of the travel ban. Fewer DVs are going to be issued, well, because of the travel ban, and now the DV ban, it's going to go to zero, right? So all these DVs that would normally be issued are not being issued, and so because of the purpose of the visa bulletin is to throttle expectations, the visa bulletin is going to freak out and make everybody current. And so I think that the visa bulletin there's going to be actually an effect like that for employment-based and family-based too, because of so many countries on the travel ban. But specifically to the DV program, look at the Visa Bulletin from 2020 and 2021. I think it's going to do the same thing. Everybody's going to go current before like March or April or something. But that's not going to be too big of a reason to celebrate, because because your case number is current, if they're not issuing DVs, that's not very helpful, right? So,
Yeah, thank you so much.
no problem.
Bimoniri is asking, what about winning a preliminary injunction for the I-485 case?
What about it? That's what we plan to do. What about is the weirdest
He
question.
or she wants to know if you are confident predicting the chances there.
Yeah, 80 to 85% in the 485 case.
And Amy Pat is asking, is there a DV lottery lawsuit incoming? We do have an interest list for that on our website. I don't know if someone on the team, I don't know how that works, can put up the link here for the interest list. Sign up on the interest list, because priority of a new group challenge is basically defined, as Curtis said earlier, how angry the team is at the policy and how many people sign up and actually want to challenge, right? Because without having plaintiffs that are experiencing an actual injury, we cannot bring a challenge just because we are angry. Curtis, do you have standing in court on your own? I mean, by now you should have standing on everything related to DV, I feel like.
Right. That's why I need my own nonprofit. So we can have organizational standing. And this is a good place for me to point out that we plan to partner with one or two nonprofits on our 485 group lawsuit, where we will have a nonprofit plaintiff that will probably be the first named plaintiff. There's a few reasons for doing that. The nonprofits are working in this space, and I kind of want to give them credit for supporting us, our efforts. They're trying to support people in the same boat, and also I think it gives the lawsuit credibility and attention. It's synergy. It's good. So do not be surprised when one of our group lawsuits has a name that's associated with a nonprofit.
Awesome. Thank you so much. Then Roger's asking if you can explain how DOS determines visa bulletin cutoff dates.
Oh, Chuck might be able to help more than me, but basically there used to be this guy named Charlie Oppenheimer, and he had this job for 30 some years, and he had developed little math equations. And when he left, we don't know how it's happening. I think they have a monkey locked in a room with a dry erase marker, and maybe they give him alcohol sometimes. I don't know. Chuck, you know?
I don't know either. It's to me, it's basically how they view the astrology.
Yeah. You got to watch to see if Mercury is in retrograde. So, I don't know if people are getting this joke. So we're saying that don't try to predict the visa bulletin. And I know I just made a prediction about the visa bulletin, so I'm a hypocrite. But it's very hard to predict what's going to happen with the visa bulletin.
Yeah. Theoretically, so Roger asked, do you know how they determine the cutoff dates? Theoretically, it should be that as many applicants as visas are available are within the numbers before the cutoff date, right? The eligible numbers. But yeah, as you two just said, since Charlie is gone, the numbers seem rather random.
Right.
We have a lottery ball, a number falls out, and that's what we're going to put on next month.
Yeah, I think they make mistakes with that too. Sometimes you'll see that okay, so they tell you what the visa bulletin is going to be the next month, and then sometimes when it comes out, it's a little different. The current one actually has a correction on that, and we've seen that once before with DVs. So they make mistakes. A human is involved, or a monkey. I don't know.
Nick's
Okay.
asking back to your. We're at 6:45. Do we have time for 3 more questions or no?
Three more, and then we're done.
Okay. Next is asking if in the I-485 lawsuit, the injunction, if that will only benefit lawsuit plaintiffs.
Most likely, and that's because The Supreme Court case in the birthright citizenship case earlier this year said that federal judges cannot give universal injunctions. There is an exception, but I'm not going to mess with the exception. I think there will be somebody seeking class certification eventually, um, and maybe they'll get it several months from now. I don't know.
But class
But
certification typically slows down the overall timeline a lot, right?
that's my experience from Jacob v. Trump in 2021. So that's not what we're doing.
Okay, thank you so much. Back on the DV topic, Maximus is asking, is having an AP status or being in administrative processing an advantage for the owner of the case? You know that it's not the real AP, so there are no issues on the case, only the issuance is left. May a judge consider that? I would say we cannot know that. They tell you it's AP, whether it's due to the policy or due to security vetting. Is there a way to find that out?
What they talk about the judge? Which lawsuit are they talking about?
The hopefully upcoming DV challenge.
Okay, the DV challenge is going to be focused on the president's proclamation. Wait a second. Not the There's not been a proclamation officially yet.
No.
On the USCIS memo and the State Department cable on how they didn't have authority to do that. It's not going to be focused on the individual applicant's eligibility. We file a lawsuit about this, it's not going to be about you, DV applicant Fred, your eligibility to get a visa. That's not what this lawsuit's going to be about.
Thank you. And then Roger was just clarifying, he meant the cutoffs for DV, not the bulletin, but I think we have clarified that in the second run as well. Yeah. And then we have a question about withholding of removal and ICE check-in that just came in. That is probably something that should be discussed with an attorney that is specialized in that, right?
Well, and an accomplished astrologist. I don't know how somebody's going to predict that. I think you definitely, yeah. Talk to an attorney who handles removal cases and ICE check-ins. We don't do that very often, and so we're not the experts about that. But our thoughts are with you. We realize that that's a very stressful situation to do a check-in. You don't know what's going to happen. It's not fair at all.
No, it's not.
I'm looking at his image. That's Mexico, right? Is that the Mexican map?
It's Cesar. Could be, yeah.
Yeah.
Yeah, sorry.
I think he has, there's a good chance that he will get, that check-in will go wrong, but talk to somebody who does them all the time. Yeah, it's cruel.
Okay. Maximus is hoping that once the DV case is filed, that a PI comes early, a saver for winners.
Okay.
And that marks the end of the questions for today.
Okay, Maximus, if you bring a preliminary injunction early, it increases the odds that it will not be successful. So careful what you wish for, okay? My vision is probably file the lawsuit and then do the injunctive relief a little bit later. I don't know. We'll see. To your second question on this visa reserve thing, I want to strangle ChatGPT for suggesting that this can ever happen. I'm sorry. We were able to get judges to reserve visas in 2020 and 2021, and then the Biden administration appealed those orders, and then the Circuit Court of Appeals for the District of Columbia ruled, and then did it again in a per diem order where all the judges agreed on it, that no, judges do not have the authority to reserve visas beyond the end of the fiscal year. So the only way that could happen would be in a court other than DC, and it would be very unlikely. So,
Awesome.
I sound angry, and I hate to end on an angry note on Christmas Eve. Oh no.
No, don't. We have so many weeks and probably years ahead of us of being angry. Let's try to be merry for the next 24 hours.
Yeah, sounds good.
Thank
Sounds good.
you.
Okay. Bye, everybody. Goodbye. Adios.
Thank you all.
Dolores.
Thank you.
Bye.